A manager sends an email. It's only 4 sentences long. He probably typed it in under a minute. He almost certainly didn't think twice about it. That email, though, that ended up costing his company $2 million. Today, I'm going to walk you through exactly how that happened, what was in the email, what the company did next, and the legal mistakes that turned a bad management decision into one of the most expensive employment cases you could ever think of. Here's what you're getting in this video. I'm going to tell you the full story, what happened, what the company did, and how it ended. Then, after each key moment, I'll pause and show you exactly what an attorney sees when they look at it. And at the end, you'll get 3 lessons from this case that you can apply to your own situation today. If you find this useful, please hit the subscribe button. New video every Tuesday. Now let's get back to our story. Act 1. Meet Sarah. Sarah had worked at the same company for 11 years. She started as an entry-level analyst. By the time this story begins, she's a senior manager. 11 years of positive performance reviews. No disciplinary history. She'd been promoted 3 times. By any objective measure, she was one of the company's strongest performers in her department. Then the company brought in a new regional director. Let's call him Mark. Mark was in his mid-30s. Sarah was 54. Within 6 months of Mark's arrival, 3 things happened. A younger, less experienced employee was promoted over Sarah for a role she had applied for. Sarah was removed from 2 major client accounts and reassigned to smaller ones. And her performance reviews, which had been consistently strong for a decade, those suddenly turned negative. Sarah raised her concerns with human resources. She was told her performance had declined. She pushed back. She asked for specifics. The specifics were vague. Then, Mark sent the email. Act 2. The email. Mark was emailing another manager about staffing decisions for an upcoming project. And in that email, he wrote this. I think we need to be building toward a younger, more energetic team culture. Sarah is a great person, but I'm not sure she fits where we're trying to go. We should start thinking about the path forward. That's it. 4 sentences. Mark hit send and moved on with his day. He probably forgot about it within the hour. Sarah was terminated 3 months later. The stated reason? Performance issues. Now, for the first lawyer's perspective on this. Let me show you what I see when I read that email. Younger, more energetic team culture. That phrase, in the context of a 54-year-old employee's termination, is direct evidence of age discrimination under the Age Discrimination in Employment Act, the ADEA. It doesn't matter that Mark said energetic instead of young. Courts look at the context. The context here is that a 54-year-old woman was being pushed out while younger employees were being promoted. I'm not sure she fits where we're trying to go. That phrase, combined with the subsequent termination, is what employment attorneys call a pretext indicator. It suggests the stated reason for termination, performance, may not be the real reason. Most discrimination cases are hard to prove because discrimination rarely announces itself. Employers are careful, but Mark put his reasoning in writing. He created what attorneys call a smoking gun, direct evidence of discriminatory intent. And here's the part that made this case so valuable. The company's attorneys didn't find the email until discovery. It had been sitting in the other manager's inbox the entire time. Act 3. Retaliation. After Sarah was terminated, she filed an EEOC complaint, age discrimination. The company received notice of the complaint, and then they made the situation significantly worse. Sarah had applied for 2 jobs at other companies. Both had called her former employer for references. In both cases, the reference provided was negative. One of those reference conversations was later characterized by the recipient as unusually hostile. Sarah, of course, didn't get either job. Her attorney subpoenaed the reference records. What they found was that the negative references came from, guess who? Mark. Filing a complaint with the EEOC is a protected activity. Giving a negative reference in response to a complaint is retaliation. It's a separate federal violation on top of the original discrimination claim. The company had just handed Sarah's attorney a second cause of action. Oops. Jumping in with another attorney analysis here. Here's what the retaliation added to this case. The original age discrimination claim was strong because of the email, but discrimination cases, even with good evidence, carry uncertainty. Juries are unpredictable. The employer might settle for a modest amount. The retaliation changed the calculus here entirely. Retaliation is often easier to prove than the underlying discrimination. The timeline is clear, the actor is identified, and the impact is documented. And retaliation that causes ongoing economic harm, like lost job opportunities, well, that adds lost wages to the damages calculation that compounds over time. Combined with the email, the company was now facing a case with direct evidence of discriminatory intent plus a clearly documented retaliatory act. That combination significantly increases the risk of a large jury verdict, which is exactly what motivates employers to settle. I've seen companies settle cases for multiples of what they might have paid if they had just acted professionally after the initial complaint. The retaliation in this case is why the number got as high as it did. Act 4. The complaint. Sarah's attorney filed suit in federal court after receiving the right to sue letter from the EEOC. The complaint alleged age discrimination under the ADEA, retaliation, and interference with prospective employment, the negative references. During discovery, the smoking gun email was produced. The company's legal team saw the email for the first time. Shortly after, settlement discussions began in earnest. The case settled before trial. The total settlement amount was just over $2 million. That number included back pay for the wages Sarah lost after termination, front pay for projected future earnings given her age and the difficulty of re-entering the workforce at 54, compensatory damages for emotional distress, damages connected to the lost job opportunities caused by the retaliatory references, and attorney's fees, which the ADEA allows prevailing plaintiffs to recover. The company also agreed to mandatory employment law training for all managers and a policy requiring all employment references to be processed through HR rather than individual managers. Safe to say, Mark was terminated shortly after the settlement. Now, here are 3 lessons I want you to take from Sarah's case. Lesson 1. Evidence you don't know exists may be the most important evidence in your case. Sarah had no idea that email existed when she was terminated. It surfaced during discovery, which is a legal process that requires both sides to produce relevant documents. If you believe you were discriminated against or retaliated against, filing the right claims triggers that discovery process. Evidence you can't see from the outside may be sitting in someone's inbox right now. Lesson 2. What happens after you complain matters as much as what happened before. Mark's termination might have resulted in a modest settlement. A bad email, a weak performance justification, a disputed termination. The retaliation doubled or tripled the value of this case. Your employer's behavior after you file a complaint is not separate from your case. It's part of it. Document everything that changes after you report. Lesson 3. The stated reason for a termination is not always the real reason, and the law gives you tools to prove it. Performance issues is the most common stated reason for discriminatory terminations because it sounds defensible. But when the performance issues appear suddenly after years of positive reviews, when they coincide with protected activity, when the criticism is vague and inconsistently applied, well, that pattern is what employment attorneys call pretext, and pretext is provable. Here's your list of takeaways from this case. 5 things. Step 1. Save every email and message related to your employment situation. Forward them to a personal email account before you lose access. Evidence you can't reach is evidence that doesn't exist. Step 2. Document the timeline. When did things change? When did the negative treatment begin? What happened right before it started? Write it down now. Step 3. Note any language in reviews, emails, or conversations that reference age, gender, race, disability, or any other protected characteristic, even indirectly. Younger energy, more dynamic, different direction. These phrases matter in context. Step 4. If you've already been terminated, be careful with your references. You have the right to know what a former employer is saying about you. Reference checking services exist for exactly this purpose. Step 5. If you believe you have a claim, consult an employment attorney before you run out of time. Most employment attorneys take discrimination cases on contingency. You pay nothing unless they win. And the clock on your EEOC deadline is already running. Sarah's case is just one version of a story I've seen play out in different forms more times than I can count. The details change, the industries change, the specific violations change. But the pattern is consistent. Employers make mistakes. They document those mistakes, and employees who know their rights are in a position to do something about it. If something about Sarah's story sounds familiar, drop it in the comments. What happened? When did it happen? And what did the company say the reason was? If you found this useful, then please hit subscribe. New video every Tuesday. And if you haven't watched the episode on how to actually file an EEOC complaint, that's the step that starts the discovery process that found Mark's email. That video is linked above. It's the practical follow-up to everything we talked about today. See you on Tuesday.